Hello guys, my name is Yuki, a student at AIU, and today I'm going to talk about this Japanese rules of international jurisdiction. And by the way, this character is a character of my university called Y. Alright, so moving on to the contents, what I'm going to speak is as follows. So I'm going to talk about historical background of Japanese rules on international jurisdiction. And I'm going to talk about Japanese standards. And then I'm going to introduce specific case called Malaysian airline case, and I would like to conclude my presentation. So first of all, historical background is this. So just recently, Japan had no specific laws that stipulate Japanese standard on international jurisdiction. What court did is they decided the jurisdiction case by case, like we've learned in this class. French company case, Malaysian airline case, and Mansei case. So again, what the court do is, because there are no common law stipulated in Japanese law, what they did is this judge, they look into the facts, and afterwards they decide the case whether or not they will admit international jurisdiction of Japanese courts. So this judgment basically becomes a case law, a precedent in Japanese traditions. So again, there was no statutory law for international jurisdiction enacted by a legislative body in Japan. However, in international society, there have been a Hague Conference on private international law. This conference and conventions were established based on the idea to promote work for the progressive unification of the rules of private international law, including the jurisdiction. So the world, like Hague Convention, was moving toward creating a common standard on jurisdiction. And what they basically talk is these two principles. So Japan, they changed their stance in 2012, and what they did is they enacted a statutory law called Act for the Partial Amendment of the Code of Civil Procedure and Civil Provisional Remedies. This was the very first official law that was enacted by the legislative body on the jurisdiction of Japanese courts. And here we see two prime ministers. This Prime Minister Kansan was the very person who initiated this discussion, but because there had been a political strife in his political life, this another Prime Minister became the one to enact this law. So this was the previous Code of Civil Procedure, but after the amendment, Japanese legislative bodies have enacted different types of explanation on jurisdiction. And the red one is the newly written laws in the Code of Civil Procedure. So it's quite different, isn't it? So to sum up, if Japanese meets provisions given in Act, then Japanese courts can admit international jurisdiction. But basically, because this is very complicated, what basically talks is if there are legal connection with Japan, in that case, then that court, Japanese court can admit international jurisdiction. And by talking about legal connection, that is decided by a residential, and a contract, and agreement. If any of the parties have a living place in Japan, then they have a legal connection. And if, in case of workers, if workers have a contract that says this worker works in Japan, then that becomes a legal connection. And lastly, if the two parties are admitted to initiate lawsuit in Japan, then that will be admitted as a legal connection. So, again, it is very super complicated, but if the plaintiffs could prove there are legal connection, then jurisdiction will be admitted. And here we see two different principles called legal certainty versus case-by-case justice. Japan previously, before 2012, was based on this idea, case-by-case justice. Basically, they look into the facts, and there are no statutory laws. But because the Hague Conference, the international society, was moving towards a principle called legal certainty, like this, it is an idea to stipulate a statutory law that talks about jurisdiction. And because, again, international society was moving towards this legal certainty, Japan enacted the law. So for the last part of my presentation, I will talk about the Malaysian airline case. So, a little bit of background. What happened is the airplane heading for Kuala Lumpur from the Penang Island was hijacked and was crashed into the sea. The family in Japan initiated a lawsuit against Malaysian Airlines to Nagoya District Court. But if you think about it, this airplane crash happened outside territory of Japan, which means outside the sovereignty of Japan. This airline is not the Japanese airline, but it is a Malaysian airline case. So if you think about it, it is almost impossible to initiate a lawsuit against Malaysian airline case, against Malaysian airline in Nagoya. But what Supreme Court said is Supreme Court acknowledged this international jurisdiction because one of the Japanese died in this crashed airplane crash, and also because this Malaysian airline case had branches in Tokyo. Supreme Court said this can be admitted as a legal connection and thus admitted international jurisdiction. So, as for my conclusion, before conclusion, this is an actual text of Article 3.9 that talks about special circumstances. It is very long, but here I want you to look at here. What it says is, a court may dismiss without prejudice the whole or part of the action when you find that there are special circumstances if the case impedes the equality between parties. And this special circumstances is very controversial. And here is my conclusion. So, the Act made very clear to the foreign countries to understand the Japanese court standard. But the thing is, again, as I explained, it still talks about special circumstance provision. And this special circumstance provision is basically based on the court's interpretation. So my conclusion will be, basically, recognition of international jurisdiction is still based on Japanese court's interpretation of the cases. And thank you for listening.